The question is that the motion be agreed to.
E te mana whakawā.
Paul Foster-Bell.
Thank you, Mr. Speaker. Sir, the Land Transfer Foreign Ownership of Land Register Amendment Bill, as introduced by the Right Honourable Member Winston Peters, unfortunately will not be supported by members on the national side going forward. And there are several reasons for that, but before I expound upon those, let me just comment on the irony. The irony of the member who just resumed his seat, referring to parchment and quills and horse-drawn carriages. There is an irony there, sir. But this is a country which has a modern land registry system already in place. This is a country where we have a very efficient means of registering and actually a legally reliable means of registering land. This is an important fact to note, sir, because as a country which has derived our heritage from our Commonwealth forebears, we have a Torrens registration system in place in New Zealand. Oh, yes, we have customary ownership too, Mr. Peters. We do have customary ownership, but we know the view that New Zealand First takes on customary ownership of land. But anyway, we have a system based on a Commonwealth heritage, but it was actually in our own part of the world, in Australasia, that the Torrens registry system was devised. In South Australia, actually, by Sir Richard Torrens, a former Premier of South Australia. So we have been innovators as well as inheritors of that proud tradition. It's back in the 1860s, Mr. Peters, when you were just a young lad, before you'd come to this place. I'm sure you were still in high school. But the system we have guarantees that the registry of land in the land registry system is actually the evidence of ownership. So it's not a system where we register of ownership. Registration is, in fact, the evidence of ownership. Now, this proposed legislation, sir, is not necessary. And the reason I believe it's not necessary is that overseas tax resident buyers already form a very, very small percentage of those who purchase land in New Zealand. It's around 3% of New Zealand property transfers that are conducted in this country involve an overseas tax resident. So this bill, sir, diverts attention from the real issue. And we know that we do have a shortage of housing in this country. We do have a shortage of housing in Auckland in particular, but also other fast-growing areas such as Tauranga and Hamilton. Even in Wellington, we hope soon to have something of a housing shortage as people flood here to take maximum advantage of the opportunities that our capital city offers, the wonderful employment opportunities, for instance, after the 1.6% reduction in unemployment here over the last year. So this bill, in diverting attention from that housing supply issue, and the National Lead Government is taking leadership with our comprehensive planning on this issue, it's also adding significant costs and delays. Sir, we have recently reviewed our Land Transfer Act in New Zealand only several months ago, and through the Government Administration Committee and in this House we looked at exactly this issue of land transfer. And in doing so we did modernise several elements that had become outdated. For instance, the Land Transfer Act 1952 was clearly devised in a time where paper registers and typewriters and manual concatenation of land registry information was the only option available. But having electronic registration, computerised registration as we now do, makes this an efficient system. And in that Select Committee hearing process on those reforms, we heard that to add in, as was suggested, I believe, by Mr Cunliffe at the time, or certainly the prospect was raised by the Honourable David Cunliffe, adding in some sort of test for foreign ownership, as this bill seeks to do. We were advised by not only the representatives of the banking industry, but also the learned and distinguished representatives of the legal profession, the Law Society, were very, very clear in their advice that this would add significant cost to those who are seeking to purchase homes. And the sorts of figures they were talking about for an average or standard mum and dad house purchase, an individual or a young couple buying a simple New Zealand house, an ordinary house, without complex ownership arrangements. So we're not talking about trusts or companies or partnerships or any other kind of arrangement. We're talking about the average New Zealander looking to buy their family home, that this sort of measure could add in the order of $1,500 perhaps $2,000. This was the advice that the Select Committee received in terms of the additional legal work that would be required to provide the verification So actually, as we already have, Inland Revenue gathers significant amounts of information, but what we are talking about here is having lawyers check the work of other lawyers, and that's where we can see something in the order of $1,500, maybe $2,000 worth of costs added to this simple family home transaction. And you can only imagine how much that would add to transactions that are more complicated. So obviously our farming communities, where you often have property in family trusts or actually in partnerships or other company or limited liability structures. So we do not want to see those extra compliance costs levelled upon the sellers or the buyers of homes and land in New Zealand, as Mr Peters' bill risks doing. Sir, this bill provides for the insertion of a new section in the Land Transfer Act 1952. That's a new section 47A, which is a registrar to keep foreign ownership of land register. So it requires the Registrar of Lands to keep an electronic register, electronic at least. That's one thing, I suppose, given the talk before of quills and feather pens and ink. But it requires people to keep, it requires the registrar to keep the person's name and nationality, the amount and value of the land involved, the district or districts in which the land is situated. And what we know is the Overseas Investment Office already collects data about these large-scale applications and their subsequent grant or rejection. But I would, sir, rather not see this extended to every single farm, every single house, every single cottage and every single village, hamlet, borough and small community in our country. There is no need to do this, sir, with such a small number of foreign owners purchasing land in New Zealand, only 3%. It's only 3%, Mr Prosser, so I think that is unnecessary. It's also possible, Mr Prosser, it's possible, you may not be aware of this, for a person's nationality and their country of tax residence to be different, or for a person to be registered as a tax resident or national of more than one country. In fact, we may even have members of this House who are tax residents or nationals of more than one country. So this means that the current information collected from property transfers is different from that required for the proposed foreign ownership of land registration. So this actually counters the point that you've made, Mr Prosser, that we're already collecting the information, so why not just extend it further? The reality is this is very different information that we're asking for. Sir, I'm also somewhat uncomfortable with this concept of foreign ownership. Foreign ownership, a term undefined in this Act, I think will give rise to enormous compliance cost issues for sellers and purchasers of land, but will also, I think, fuel a xenophobic argument that foreigners should not be able to own land in New Zealand. I think we should be thankful for the significant investment, the significant capital investment that foreign investors make when they come to New Zealand, set up businesses here, employ people, including many, many New Zealanders, and we would not want to put them off. A final point that I would make, sir, regards our trade agreements. So we have a number of trade agreements where we have the ability to modify the Land Transfer Act 1952, but only in a non-discriminatory fashion. So, for instance, our Closer Economic Relations Investment Protocol Agreement with Australia concluded in 2013, we could not put up potential barriers to Australian investment whilst discriminating in that way against others. So this actually makes it a very complicated situation. We must adhere to the international covenants and agreements that we've concluded in good faith that also allow New Zealanders the opportunity to invest elsewhere, that allow New Zealanders the ability to go and invest in Australia, as they are doing in increasing numbers, given the strength of the New Zealand economy and the weakness of the Australian economy. But I think the specific legal advice from the Ministry of Foreign Affairs and Trade, when it comes, should be taken into account, because there needs to be a detailed assessment of whether this bill would breach our international obligations and our trade obligations that we have signed up to in good faith. Sir, this bill is unnecessary. It could potentially be very expensive, and for that reason I would argue that it progress no further.
The Honourable David Cunliffe.